All right. Welcome to the Insolvency Law Academy's Insolvency Scholars Forum podcast series. This series is on cryptocurrencies and AI and insolvency. My name is Laura Cordes, and I am co-chair of the Insolvency Scholars Forum and professor of law at Arizona State University's Sandra Day O'Connor College of Law in the United States. And today I am so excited to be joined by Professor Rebecca Perry. Rebecca is a professor at Nottingham Law School, and she is the co-director of the Center for Law, Emerging Technologies, and Business. She's also the leader of the research network Mapping Gray Areas and International Legal Approaches to the Failure of Crypto Firms. Very salient to our discussion today. Welcome, Rebecca. I'm so pleased to be speaking with you.
Yes, thanks for the invitation, and it's great to be speaking with you likewise.
So just to start us off, I thought maybe you could tell us a little bit about what motivates your research into AI, emerging technologies, crypto. Was there something in particular that really sort of inspired you to look into these areas?
Yeah, so I've been working on these areas for a while now, and so far as AI is concerned, it's just been interesting to see how rapidly it's spread and the ways it's being used and how humans fit into that, as well as how it doesn't suit everybody equally. And there can be some who are left behind by it. And I think we're all finding our feet so far as AI is concerned. So far as digital technologies are concerned, what interests me is how many of them there are and how really we take them for granted, operating in the background. We're doing this discussion over Zoom, and we can see from that that there are many technologies that get from get the meeting from me to you. So there's the Zoom app itself, and then that is transmitted through the university's Wi-Fi system. Then there are lots of technologies in between, so internet service providers, different directories, internet exchange points, and and ultimately the meeting is being transmitted across submarine cables going across the Atlantic, and uh, the same on the way back. So at each stage of that, and I've not mentioned other things that cloud servers and so on, that if any one of them was to go wrong, it would cause mayhem and uh, significant economic loss through transactions that can't go ahead, inconvenience to people's lives, and it would be so much worse in the case of an insolvency. I got into that side of things originally because on my corporate insolvency module, there was a student who wasn't a lawyer by background. He was a computer science person working on cybersecurity. And he did his dissertation on what happens if cloud computing servers fail. So these are the data centers that so much relies on these days. And I hadn't even thought about that. I didn't really understand what cloud computing was. And so I wrote a paper on that, and together with the student, and that side of things just developed from that. So far as the
That's
crypto is concerned, that came through a PhD student that a junior colleague of mine was wanting to supervise a PhD project on crypto and in particular blockchain. And at that stage, which would have been about 10 years ago, I didn't really know what blockchain was. I'd heard of it, but like I think many didn't know or care what it really meant. Just that was for other people. But because in our university we have to have an experienced supervisor on any supervision team, and my colleague was junior, I said I'd be the second supervisor so that his team was fine under the regulations. So a year went by. I learned a lot about blockchain. And it was good that I did that, because after a year, that colleague left, and who was left in charge? I was. So through supervising that PhD, I learned a lot about blockchain and crypto, all the different players within the crypto universe, the crypto exchanges, different types, and all of them, the many crypto assets that there are, the stable coins and the what we call unbacked crypto that doesn't have any asset backing, and all of the meme coins that have spread from that. And there are lots of legal issues there around national laws being insufficient to regulate what are multinational businesses, inherently multinational, because they're online, and it can be difficult for regulatory systems to catch up with what's going on in the crypto sphere.
Absolutely. And I hope we'll dive into that in a little bit. But thank you so much for that background. Starting maybe with AI, can you tell us a little bit more about AI and specifically how it's being used and some issues maybe that are arising in insolvency proceedings specifically?
Yeah, so there is potential for AI to be used at every stage of the insolvency process. And a lot of money and work is going into building specialist tools and AI, use of AI in procedures. So we've got things like case prediction. We've long had formulae that have been applied to identify companies that are likely to fail, such as the Altman Z score. And AI is being used to refine the accuracy of those models, because it can look at so many more different factors. It's
Yeah.
also useful in case management. Lots of countries have got court bottlenecks that are really not corporate rescue friendly. Often companies that are in difficulties need assistance quickly, and things can get caught up in court backlogs. And AI can help with that to some extent, with the case management, case administration, and perhaps a triage system, so that the most urgent cases are prioritized and not caught up in backlogs. So there can be good uses of AI, and it extends to the post-insolvency scenario as well, that the AI can be used to comb through reports of cases that have completed, to look for problems of indicative of money laundering, for example, or some sort of cybercrime. And that's being used by the UK Insolvency Service as an example of that. There's also large use among insolvency professionals. Coyote Akintola has done a good project looking at the proportion of insolvency practitioners who use AI tools. And there was a large number of them, particularly using generative AI. But so far as generative AI tools are concerned, we also, of course, have to be wary about those, not to put confidential information into those. And there's also the issue that AI's arrived very quickly. It seems so very authoritative that we can be overawed by it initially. And I think everybody who's got experience of using it has found that it's entirely fallible, that there can be errors, hallucinations, And we do have to be very careful with AI output to make sure that we aren't inheriting its errors. AI will try hard to find an answer to your question, and if there isn't one, it will make one up. And there's lots of case law of uh, different parties mistakenly submitting what look like very polished submissions, but which have got, if you know about the subject, glaring errors as to either cases or legislation. And there was a very high profile law firm caught out by that in the UK, that the AI had fabricated a section of our insolvency rules, and that had appeared in the court submission, which was very embarrassing for them. But I think so far as AI is concerned, we've all got to be learn how best to use it. That it's quite clear that AI isn't as wonderful as we might first have thought. When generative AI came along, we were all thinking, "Oh, this is going to come for our jobs." But I think as time has gone on, what we've realised is that people's jobs are actually much more complicated than we've given them credit for, and that they rely on experience and tacit knowledge that the AI won't have. And I think there's a revision of that idea that AI can take over and we can all retire. There are definitely areas where human input is much better. It can be a useful tool, yes, but we do need to be careful in how we use it, so that we use efficient prompts, so that it's not using too many resources. And every inefficiency in prompts by users is cumulative and results in greater use of data centers, which leads to more use of electricity and more use of water. So we all have to be careful about efficiency in how we deal with AI. We do also need to take ownership of the work that we're doing, so that we don't repeat these hallucinations or inaccuracies, that we don't subcontract our thinking to the AI, and that we are the ones driving the bus. It's not the AI that's doing it. And I think one of the most important things is for companies not to see AI as something that can enable them to cut half of their workforce, and in particular junior staff, because that's going to lead to a pipeline issue that we very much do need human skills. And in 10 years' time, if we've not developed those skills in graduates, new employees, and there's going to be nobody with the relevant level of skill and experience to be the next set of leaders. So I think it's very important to protect trainee jobs and not store up trouble in future.
I think that's such a great point, and probably very reassuring for students to hear as they are thinking about entering the workforce. So maybe kind of pulling along that same thread a little bit, you've already identified some challenges, just for companies and for lawyers in particular to be thinking about as we all see AI and work with AI. But maybe from a regulatory or policymaking standpoint, what other challenges do you see, especially as AI use just expands and, more and more companies, more and more jurisdictions adopt it? How, from a sort of regulatory or policymaking perspective, do you begin to think about addressing these challenges on maybe a larger level?
Yes, it's tricky because we do hear of good examples of how AI is being used in particular countries or by particular companies, but there very much would be winners and losers in that. So you have good AI use in Colombia that has enabled them to transform their way of doing things in case administration. But a tool you trained on that system wouldn't necessarily easily be transferable to even neighboring countries, because so much of the training is country specific. Law exists in silos. And so if you have bespoke tools trained on one system, they can't necessarily be easily adapted by other countries to their systems. So we have a transferability problem. The same that sophisticated legal tools can be developed by major in-house firms based on their records, and those aren't available to smaller firms, which widens the resource gap. And so far as use by different countries is concerned, developing these bespoke tools, if they can't be copied from other countries or adapted from other countries, it's not necessarily going to be a high priority for resource to develop sophisticated tools, because there'll be other things that are more demanding on the public purse.
That makes complete sense. So turning briefly now just to crypto, I wanted to ask about, crypto assets and sort of the regulation of those. I know in the US, we have seen the passage of the Genius Act, which does create, I suppose, a regulatory framework for payment stablecoins, which is just sort of one very narrow slice of all of this. But when we think about crypto and how much that has expanded over the years, how do we think about regulating crypto, or even just providing guidelines? What are sort of the challenges and pitfalls that you see here?
Yes, it's a tricky one. There's a lot of legislative attention paid to stable coins, not just in the US with the Genius Act, but in other countries as well. Because of the risk to fiat currencies, that in some countries you would see stable coins almost taking the place potentially of domestic currencies. That there's a lot of regulatory attention paid to those. But other aspects of crypto, where there is a real prospect of consumers misunderstanding the risks of what they're investing in and making ill-informed decisions as a result of that, there hasn't been as much regulatory attention paid. So if you look at the terms and conditions of a typical crypto exchange or unbacked crypto, the stablecoin companies have extensive and clear contracts. Other crypto businesses do not. And there will often be a lack of clarity as to the issues that would be really important in an insolvency. So if you used a crypto exchange and have deposited fiat currency, or you've got them playing a custodial function so far as your crypto is concerned, in an insolvency, there are going to be key questions. Do you have a proprietary claim? So are they acting in a professional capacity that would give rise to a fiduciary claim, for example? Are the assets segregated? Are they mixed with other clients' crypto? Are they mixed with the exchange's crypto? All of these questions would be very important in an insolvency, but having looked at the terms and conditions of 175 crypto businesses, there wasn't always a great deal of clarity as to what happens in the event of an insolvency. And in any case, um, it's tricky because consumers aren't going to read the terms and conditions. They're often hidden at the foot of the website of the crypto business. And if you were to read them, you wouldn't necessarily understand what the insolvency issues were. But it's not a sufficient, there's not a sufficient public interest in regulation of unbacked crypto. The public interest in regulating stable coins is clear. Unbacked crypto is both only a small proportion of economic activity, but also it's one that's very difficult to regulate. You have what are multinational businesses that engage in regulatory arbitrage. They go to permissive jurisdictions. They try and maintain an ambiguous national identity, and because of that, it makes the insolvency issues quite difficult to predict. We have other issues as well. We have different sorts of stable coin, different sorts of crypto. We have the stable coins which have asset backing. You have lots of other types of crypto asset that don't have asset backing and rely solely on market sentiment for their value. And what we have as well are what's called utility tokens, and those can be used for all sorts of different purposes. Sometimes they are just for their currency on the crypto entity's website, but they can be used for other things as well. And there are 4 or 5 different uses for crypto, for utility tokens that the US regulator, I think the SEC, has identified. And it's what the crypto industry, by contrast, is very unclear about. So there's a lot of ambiguity as to how we refer to crypto. And then so far as insolvencies are concerned, the issue is around uncertainties and what happens in the event of an insolvency. It's easy for crypto firms to relocate. We've seen lots of examples of that, and examples of where they end up in insolvency not being the jurisdiction that they're most closely associated with. And any Indian listeners will be familiar with the Wazir X case, which had 6.6 million Indian customers. But because its parent company was in Singapore, its entire restructuring was dealt with in Singapore. Now, obviously, Singapore's a well-regulated jurisdiction with good restructuring expertise, but because the bulk of the customers were in India, it highlights how consumers can be wrong-footed in insolvencies and can end up having their case being considered in an entirely different jurisdiction. So we've got issues around regulatory arbitrage, seeking permissive jurisdictions. We've got potential for forum shopping in insolvency. And one of the ones that's an issue that's often been overlooked is that although we've got plenty of cases that identify crypto as property in a whole bunch of common law jurisdictions, it's much more complicated in civil law jurisdictions. And in the civil law world, there is debate as to how crypto fits within the civil law taxonomy, and it's not necessarily that straightforward. And it's not something that the EU's MiCA deals with. That has clear approaches to um, various issues, but doesn't, so far as the laws of the member states are concerned, have any harmonizing rule that crypto is property. And that's in particular the unbacked crypto. I think stable coins have much greater similarity to existing instruments, but unbacked crypto is something new that we all have to figure with. And although common law jurisdictions have much more flexibility about that, it's not as easy in civil law jurisdictions.
So lots of challenges, I think, with crypto and, obviously lots for the legal world to think about, but also real impacts on consumers and, sort of the everyday users of these assets and these services. So maybe just looking for a bright side, is there something particularly innovative, whether it's from a particular jurisdiction or approach, that you think this really is on the right track when it comes to dealing with crypto assets? Are there, yeah, I don't know, is there sort of an example that we might be able to look to of somebody or some concept or approach that's sort of on the right, doing the right things when it comes to crypto, especially maybe these unbacked crypto assets where we don't have a lot of regulation, where we have a lot of uncertainty.
Yeah, there are quite a lot of jurisdictions that have enacted quite developed uh, legal framework so far as crypto is concerned. Um, ones that spring to mind are, for example, the United Arab Emirates has set itself out expressly as a crypto-friendly jurisdiction. It's got um, institutions that deal with crypto, and so it's got this crypto-specific regulatory structure rather than trying to fit it in with its existing securities law, for example. And we've got other examples. I think Hong Kong's got a licensing regime for virtual asset trading platforms. It's trying to deal with crypto in a proactive way. Japan led the way really with the early Mt. Gox case in 2014, and it showed how these cases can be dealt with. But that's the main example of a country that's had to learn the hard way and put legislation in, having gone through what was a difficult case. Thinking of some other ones, the UK has taken quite a soft law approach in developing things like the UK jurisdiction task force guidelines on digital assets. Because judges are involved in that, there's quite a large amount of soft law guidance as to how crypto will be dealt with, alongside the Law Commission's report, which led to legislation to expressly recognise crypto as property. And the Financial Conduct Authority has taken quite an observatory approach, initially advising people that if you invest in crypto, you will lose all your money, or you're likely to lose all your money. They were not that pessimistic. But they've now got a regulatory scheme in place, which is the product of quite a good amount of research and consultation, so that the UK now has, I think, quite a good framework in place. But nobody's got to grips with Bitcoin.
Yeah, that's probably something for the future. So a challenge to
Yeah,
keep rolling over. But it's good to
yeah.
know there are jurisdictions out there that are thinking about obviously this in even in a proactive way, and that there's a lot of different examples for how to think about this, whether it's soft law or not, or getting different bodies involved, or lawmaking bodies or judges. So it's I think heartening to know that there are a lot of different approaches to thinking about these issues. Well, I think that's all I have. Thank you so much, Rebecca, for your time today and for sharing your expertise with us. And I want to thank everyone for tuning in to this podcast from the Insolvency Law Academy. Thank you so much again, and have a lovely day.
Thank you.